This is Michael Popok with a Legal AF Hot Take. I want to talk about the Appellate Division's bailout of Donald Trump recently and what it may portend for the future and the appeal for Donald Trump concerning the $465 million civil fraud judgment. I don't think that the Appellate Division First Department, led by the presiding justice, Justice Renwick, just picked a $175 million bond amount issue out of thin air or out of their backsides. If they reduce the amount, it's not because that they believe that Donald Trump can't come up with the scratch. In other words, they didn't bail him out, I don't believe, and most court watchers don't believe. They didn't bail out Donald Trump and randomly pick a $175 million number because they think that's all he can pay, especially in the same week where his Truth Social, Trump Media Technology Group went public, and at one point, his on-paper net worth hit $5 billion. I mean, it later, stock market later corrected itself during the day after this feverish run-up, but it did end up 14 points higher than when it started. So the justices aren't blind. They know he's got $3 to $5 billion of paper assets in the stock market. He's got $500 million of cash. He owns buildings with his name on it, whatever their value. So they know he could come up with the money. Why $175 million? It's got to be troubling, and this is the manage expectation part of this hot take for the Attorney General, because they've got to be scratching their head thinking, why did they reduce the amount by more than 60% in the amount of the undertaking? Because a reasonable position, a reasonable analysis, and one that I've seen in groups that I participate in that are ardent appeal and court watchers, is that there is a flaw in the Judge Engoron's judgment that the appellate court is concerned about, and they've already made the deduct. They've already lowered the amount to fit a more likely judgment that they are going to affirm on appeal. In other words, this may signal that the Appellate Division First Department, the intermediary appellate court that sits in Manhattan, is not going to affirm the entirety of Judge Engoron's money judgments, a part of his order, for the $465 million, but will do so at some smaller, lower amount, closer to $175 million. Now, one court watcher that I follow, and I agree with the math here, calculated properly that one aspect of the appeal is the argument by Donald Trump's side that the trial judge, Judge Engoron, did not properly apply a prior appellate ruling by the same First Department that came out in 2023, People versus Trump, in which the appellate department effectively validated Judge Engoron's prior rulings and summary judgment. However, found that as it related to certain of the claims, that there had to be they had to take a scalpel to calculate, or a scalpel to cut off certain transactions that fell outside the statute of limitations period. This may be one of the flaws or weaknesses in the ultimate judgment that the appellate division is concerned about, that Judge Engoron did not apply the appellate ruling properly, which is what the Trump position has been as it relates to prejudgment damages before interest. That number that the Trump side claims is the error is $285 million of error because of an improper application of the appellate decision that had already been ruled before the trial started. In other words, the appellate court telling Judge Engoron, you need to calculate damages this way. You need to leave out transactions that fall outside the statute of limitations that way. And if the reason I bring up the $285 million number is because it's very close to the amount of break they just gave him. I mean, they just gave him a break of about $280 million. And $285 million is the number that the Trump organization says was miscalculated by the judge in not properly applying the appellate decision from the past. I mean, they knocked off $289.5 million. And there's a $285 million issue that Trump has raised. So we could do the math. There's also an argument that they don't like the methodology that the judge used in calculating the damages, that they're likely, as an appellate division reviewing the work of Judge Engoron, that they're likely okay under the executive law powers that are being applied here, which is Executive Law 63-12 in New York, which has very robust and broad powers for the New York Attorney General to stop persistent fraud and to claw back through disgorgement, not damages. We'll talk about this on a Patreon for Legal AF where we can do a deeper dive. Disgorgement is taking ill-gotten gains away from a party, money they should never have obtained except they purposely played an unlevel playing field of their own creation, right? They cheated. And the money that they earn by cheating is then taken from them in what we call disgorgement. It's disgorging the amount that they've taken. It's not a measure of damage. So damages relates to how much suffering or injury another party has incurred or suffered as a result of somebody else's bad acts, breach of contract, a tort, negligence, fraud, and the like. That's not a damage. A disgorgement is how much did you make lying to banks, Donald Trump? How much did you make lying to insurance companies? How much did you make lying to counterparties? How much did you make lying to cities when you were signing contracts? That's the amount that you're not going to be allowed to keep. It's going to be disgorged. And the question is, does this $175 million number, not picked out of thin air, if my hypothesis is right, signal that the appellate division, in reviewing the briefs in order to enter their order, lowering the amount of the undertaking or bond Donald Trump has to put up, is also signaling that they're troubled by certain aspects of the methodology for disgorgement calculation that the court used, Judge Engoron used. And if you're the Attorney General, Letitia James, in her office, you got to be troubled by the $175 million number. I mean, I know she came out after and made a statement that, it's full steam ahead. And if the $175 million is combined with his buildings that we'll go after if we have to, and we'll register the judgment in different counties against his assets is more than enough. But she's got to be troubled, and her appellate people have got to be troubled about what this may signal. It doesn't, I think what my point of my hot take is, it's not agnostic. It's not just a number. It means something. And it can't mean that the 5 justices of the appellate division in New York think that Donald Trump doesn't have enough money to post the full $465 million based on the filings that he made. They do. And so if you're doing the math, did they subtract the amount of improper calculation that the Trump side claims happened because of a misapplication of a prior appeal decision by the trial judge? It's one of those rare circumstances where during the course of the trial, there was an appeal on an issue. It went up to the appellate division. The appellate division upheld Engoron's prior rulings on summary judgment and on motions to dismiss, but gave him instructions on how to handle the case going forward. If he screwed that up to the point of Donald Trump's number, 285, 289 million. That's the subtract. That's the deduct. At least it signals, as far as I'm concerned, that there is a hole or a defect in some of the analysis used by the judge in calculating damages in calculating the amount of disgorgement. Almost forgot my own lesson. And that they're allowing him to post a bond that is more right-sized to the amount of ultimate judgment they believe, as an appellate court, they're going to affirm for Judge Engoron. But there's no other way to read this. If anybody thinks that they're going to allow a $175 million bond to be posted and they're going to affirm a judgment much higher than that, I think that's delusional at this point. I think the only way to interpret this, the only way for the Letitia James to interpret this, as she prepares for a September oral argument and briefing in August on this issue, is that she's got to address and be prepared to address in her briefing their concern with the amount of the judgment. I mean, I'll give an example where there may be some weakness in the analysis by Judge Engoron. And it has to do with Mar-a-Lago. That property, because of all of its conservation easements and deed restrictions and deals that Donald Trump cut with the village of Palm Beach in order to live in Mar-a-Lago and not develop it as single family houses. There's all sorts of restrictions on the value of that property that can't be taken off. It burdens the property, as we say in land use and zoning world. It travels with the property. It burdens the property, and it lowers the property. So the property can't be used for its highest and best use, another appraisal term or real estate term, but you have to value it at the property with all of its burdened easements, assessments, restrictions, zoning restrictions, and the like. Now, I practiced law for a long time in Florida. I lived in Palm Beach. I know where Mar-a-Lago is. I've had lunch and dinner around the corner at various places, and I practice land use and zoning law. I don't think the judge got that number right. You can't use the assessment from the tax assessor and say that is the proper value of a piece of property. I mean, when I lived in Florida and I had a home, the tax assessment was about first of all, it was about 5 years lagging. My property was worth, probably twice what the tax assessor said it was worth by the time they got around to tax assessment world. Now, I didn't care because the lower the value for tax assessment purposes, the lower my taxes. So I didn't want them, and nobody did want them to get to market value. So they're not a fair market value assessment. They're a tax appraisal assessment, a tax assessor assessment, and it always runs lower. It's never 1-to-1. It may be three times less, 5 times less, but it's less. But to Judge Engoron, because he doesn't like the fact that Donald Trump got a tax break, he said, well, your whole property is only worth, I don't know, some number like 28 million, 30 million. That property, even as a single family house or as a club in Palm Beach on 15 acres on the beach, right? It sits between the beach and the lagoon or the intercoastal. It sits between the Mar and the Lago, to use the terms of the home, is worth, if my guess based on post-COVID, not a real estate appraiser, but I do know my way around real estate in Florida, I would say it's probably between, 100 million, somewhere between 100 and 125 million. It's not a billion. It's not Donald Trump's number. I'll just leave you on that. It's not Donald Trump's number. It's not $1 billion. But, there's plenty of single-family homes that are smaller than this one, and clubs that are smaller than this one that have gone for well in excess of 100 million. 100 million, 130 million, 150 million. I think it's less than 200 million and more than 100 million. Somewhere between that. That's the breadbox, right? Bigger than 100, less than 200, somewhere in there. So right there, given the amount that the judge assigned to Mar-a-Lago, there's 50, 60, 70 million dollars of potential error that could be addressed. And that comes off the top. So I think the purpose of this, I know the purpose of this hot take, is to not blow smoke or sunshine. The $175 million number for me is an indicator that there is something wrong with the calculations made by the judge, either in the application of the appellate decision that happened during the course of the case that needed to be applied during the trial and summary judgment, or in another way that the judge calculated disgorgement as opposed to damage. And then the appellate court, on an emergency basis, taking what we call in the law a blue pencil, editing down the number, right? Lowering the number, scratching it out, and giving him his 10 days. Now, I think it's 6.5 days to post the bond, or what we call an undertaking. He can do it by cash. He can get a bond for the 175, whatever it is. And then just to round out the hot take in terms of timing, the First Department Appellate Division of New York, sitting in Manhattan, like most of the appellate divisions, doesn't hear oral argument in the summer. So you have to skip the summer based on the briefing schedule. Donald Trump will have to file his brief by July the 8th. And we'll see it, and we'll cover it on Legal AF and on the MeidasTouch network. Then the Attorney General has until August 7th to file her brief. Then there's one more brief by Donald Trump on August 16th, because the party taking the appeal gets 2 briefs, and the party opposing the appeal gets 1. So by the 16th of August, the matter is fully briefed. but there's no August oral argument in New York. You have to wait till September. So there'll be a September hearing, oral argument, that we'll be able to report on the MeidasTouch network. But I wanted to give you this little bit of a primer about the 175 and what I think it means, and that it doesn't mean nothing. We'll continue to follow and analyze events in the world of politics and justice right here on Legal AF and on the MeidasTouch network. Help them get to 3 million free subscribers before the election. Really important. They're going to get there with your help. Just go out and hit free subscribe. That's all you really have to do. There's other ways to follow Legal AF. We have a podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this YouTube channel, and then on audio podcast platforms, wherever you get your audio podcasts from. We do hot takes like this, but we extend them and we curate it into 4 or 5 stories, developments at the intersection of law and politics. And we have Ben Meiselas and me on Saturdays, Karen Friedman and me on Wednesdays. And then we do hot takes like this during the week to catch you up in real time with a deeper dive and analysis. And if you like what I'm doing, I'm Michael Popok. Give me a thumbs up, leave a comment. It helps with the ratings, helps keeps the content on the air. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.